I'm not one much for sort of long introductions, but Commissioner Slaughter had joined the FTC in May 2018.
Yep.
And has now been into her 5th year as commissioner. Before that, an esteemed career on the Hill in the Senate, in particular for Senator Schumer. And now the longest serving commissioner, the veteran of the FTC. So I've got a bunch of specific fun stuff on merger guidelines and rulemaking and sort of things that we'll talk about all day here. But let's start 30,000 foot. How do you like the job? But in particular, from the time you started to now, anything that you've learned that surprised you in how you think about the agency and its work, and sort of your overall impressions as you from midway through year 5?
Well, the short answer is I love the job. It is such an honor and such a privilege to get to do every day. I think of our work fundamentally as having the obligation and the responsibility to help people within the outlines that our statutory authority sets out. And that is an incredible opportunity and an incredible privilege. And it's especially a privilege to do it alongside the staff at the agency who share that passion and that commitment to the mission. I think the things that have impressed and surprised me the most over my time there is, first, understanding the depth and breadth of that passion among the staff. It has really been a joy to get to work with them and talk to them and support them in the work that they're doing. And, on the other side, among the things that have surprised me, well, let me back up. When I started at the FTC, I knew a fair amount about competition and consumer protection law and policy, but I had never been at the agency. And I spent most of my first 6 months really just meeting with staff across the agency and all of the divisions and hearing from them about what they thought worked well, what they liked, what was challenging for them, and trying to learn more from the inside out. And I've continued those conversations over the time that I've been there, periodically meeting with staff and just checking in. And I'm just working through another round of those right now, so it's very much on my mind. So one of the things that has been so exciting to see is the passion and the commitment and the dedication of the staff. Something that was surprising to me in the other direction was how very siloed the missions of the FTC have historically been. We have one statute, the FTC Act, that bans unfair and deceptive acts and practices and unfair methods of competition, and we treat those two things as entirely distinct, and historically they have really operated like two agencies within one building. And I think that misses opportunities and obligations for us. So something that I'm really interested in building on is the work we've developed to do more cross-agency and intra-agency collaboration and making sure we're not looking at issues myopically, but instead really trying to understand where particular matters sound in both competition and consumer protection. Or where a consumer protection remedy might have competition implications, and use I think we have an institutional advantage having all of those facilities in-house, and trying to use that as an advantage is something that I think is a real opportunity for us.
That particular last bit, the interplay between Bureau of Competition, Bureau of Consumer Protection, and those missions. We've got at least one former Bureau of Economics director in the room, and you could line a hallway and fill at least one of these tables with former Bureau of Economics directors who start and they come in, they say, you know what I'm going to do? I'm going to help bridge the gap between those two by using sort of principles of economics. Now, there are other ways to do the bridging. All 10 of those would sit at a table and say, so that didn't work out for me. And I think that observation that they are siloed, it's one I certainly share. I think the question goes something like, why do you think that is, and what can be Is it at the investigation stage? Is it analytical? Is it something other than that?
Yeah, I mean, I think it's habit is really where we are. A lot of the ways things develop are because they start to develop in a certain direction and then they get sort of reinforced. And so, what I think about a lot is how do we develop a different kind of muscle? We have staff, for the most part in DC, our staff in the Bureau of Competition and Consumer Protection do exclusively that work. In some of our regional offices, we have staff who do both work. And the commissioners obviously look at all of the range of cases. But if you are only trained to look at antitrust issues, you might not have the experience issue spotting a particular UDAP problem when you get a case. And so making sure that we populate some of our investigations that seem likely to raise issues on both sides of the house with staff who have the experience doing that issue spotting, I think, is one way to start thinking about it. And I think it's really important to start doing that early on in cases, because what's really frustrating is when staff work so hard to develop a particular theory and they get to the end of an investigation and then have commissioners come in and say, well, why didn't you think about this or why didn't you think about that? When it's really very difficult to go back and do it differently. So I think something that we're working really hard on doing, or I'm working really hard on doing, is surfacing early in cases where I think that there's going to be something that raises different questions than they might traditionally think under like the Clayton Act or the Sherman Act or just under a UDAP investigation.
So what I hope is a fun question. Commissioner Slaughter, version 2023, gets to talk to newly confirmed Commissioner Slaughter, May 2nd, 2018, and give some advice about what you would do differently, do the same, but either which way. What would you tell you then, given what you've done over the last 4.5 years?
Well, I think I have loved my job since the day I got it. I think I love it more now because I understand it better now and I understand the agency better now. I felt very much at the beginning like I was constantly maybe struggling to understand the universe around me, and that took an enormous volume of work to do. And now I can look at matters pretty quickly and know what is going to be important or different or interesting to me. And so I think what I wish I had known then was that I would figure that I would hit that point and that it wouldn't take that long to figure that out. I also think that, candidly, I think I suffered from some intimidation at the beginning of my time where I wasn't, there are a lot of people who tell you this is how things have to be. And I think I didn't do a good enough job trusting my instincts early on when I didn't agree with some of those arguments. And so I wish I'd been a little bit more confident about that then. I don't have that problem now, which is better.
So back to Commissioner Slaughter, 2023, sort of moving forward, renomination pending, going to be at the agency. What are your priorities sort of here on out, having from your agency experiences to date, or continue to be priorities, new things that you think are on the horizon for the agency and are especially important to you?
Well, one of the things I just mentioned is making sure that we're really thinking with the entirety of our statutory authority when we grapple particular problems and not trying to silo issues with a limited set of tools. A related question or a related goal, I think, is really making sure we're utilizing all the tools in our statutory toolbox and being as effective as possible in doing those. And then that last point is the third one I'd make, which is that making sure that we're not only bringing good cases and looking at the full spectrum of our authority, but we're bringing them in the most effective way possible and really focusing on ensuring deterrence in our work. What I want is to have fewer cases to bring, because there are fewer problems in the market, because when we bring a case or issue a rule, the market gets the message that the law should not be violated again. And so that means thinking carefully about what are the right remedies, what tools do we have to effectively impose discipline on markets?
I'm going to shift gears a little. I think still, if not 30,000 feet, 25 or so, and talk a little bit about winning and losing for the agency. Every time the agency wins or loses a case, if they lose, there's a lot about what the record is, a lot of talk, I think mostly some of it silly, about the idea of losing cases to win legislation later. I don't think anybody thinks either the staff or commissioners are interested in losing cases. But I think at the commission level, case selection and how much risk you take on with rules, with enforcement actions, et cetera, sort of an important component of the commission's sort of portfolio of enforcement decisions. So I've got a quote from you. This is from the dissent in the Facebook settlement, the Cambridge Analytica one. Even an adverse finding or lackluster remedy can further the public good. Disappointing results help build the public cases that there are deficits in the law that Congress must address. I have sympathy for this idea. I think when I was commissioner, I was on record for saying we should lose more cases. There's a famous George Stigler quote says, if you're never late for a flight, you're not doing it right. You're sort of not efficient. And in that spirit, obviously you want to win the cases that you litigate. The standard, and maybe some in the room will know this and others not, when a commissioner votes out a case to go litigate in federal court is, do I have reason to believe that there is a law violation? Go read all of the reason to believe cases that you want, and there's not a standard. Commissioners either have a reason to believe or they don't. How do you? It's reason to believe. I'm an econ guy, so is it more likely than not? Is it 10%? Is it 1%? Are you willing to say there's reason to believe there's a violation and vote out a case? It's 1%, but maybe the case helps establish some important principle of the law. How do you think about how much risk to take on the agency's enforcement and rulemaking portfolio?
It's a really good question, and I think there isn't a general answer to it. I think it is a case-specific and fact-specific determination for a number of the following reasons. The first thing is I think that there has been for a long time an assumption that the value of a litigated case is entirely the remedy that is achieved at the end of a successful trial. And you weigh, I have seen the commission traditionally weigh, well, if we went to trial, we might expect this remedy, and you discount it by some percentage that they might lose. And if we settle, here's a remedy we could get, and if this is as much as we could expect to get at trial, then we should just take the settlement because it's more efficient and it's certain. And I have always thought that math was wrong, and this is a little bit what I wrote about in my Facebook dissent, because first of all, I think we are missing some value that should be ascribed at different steps of the process. I think there is value in a publicly litigated trial in the first instance. I think there's open, good government transparency value there. The agency has to put on its case. The defense can put on its case, and that is available for the public to see. I think it has transparency value. I think it can have a disciplining effect on the companies to not want to have to put their executives up to testify. I think that can change market behavior. I think a finding of liability has value that we are not often getting in settlements, if ever. I think that can be very, very material. So all of those things are really important in addition to remedy. So that's some of what I think about. Going back to your question about what is enough to have reason to believe, it is absolutely important, consistent with our oath of office and our statutory duties, that we only vote out cases where we think the law and the facts support them. I don't think that is a controversial question, but the statutes that we enforce don't require, exactly as you articulated, certainty. And in fact, we often can't have certainty because facts have to be developed in discovery and through litigation. So we have to have, there's a reason the standard is vague and reason to believe, and that we are entrusted with the exercise of judgment. And then the third point, I lost track. The last point that I'd make is some of the question that we have to ask isn't just about the specific case at hand, but how do we balance risk and resource management across the agency, whether it's across a specific division that may be in multiple litigations at the same time or across multiple divisions of the agency. And that's a question that's not going to be the same at every moment in time or for every case. And so I think that that's part of responsible management, is to say, here is a case where, we think that the law and the facts support a challenge. We need to go into it, even if, there is some risk that we might not win at the end of the day, as long as we have reason to believe that the law has been violated. But there are other times where that's not worth the resource investment, given the rest of the docket before the commission.
Let me ask a variant of the same question, but sort of move to the appeal level. So at the appeal level, you've had reason to believe, you voted out a complaint, and meta within comes to mind, and I'm not going to ask you anything about specific cases, but like that's one where the agency decided not to appeal. There's others where they decide to appeal. And it strikes me, I think this was less a priority at the time when I was at the agency, sort of bringing cases to move the law. A little bit more before my time, at the reverse payment split and trying to move the law in that area in particular, and some of the state action cases. So that sort of priority kind of ebbs and flows and moves to different places. It feels like a bigger focus of the current commission. It sort of strikes me there's sort of one thing to decide whether or not to bring the case at the district court, but once you've done it, how do you think about when to appeal and when not to in those cases?
Yeah, so I think there are a couple of questions at play. And I think I actually can talk about the meta within federal court decision, because I think it's a good example. The standard on appeal, obviously, is going to be whether the judge got the questions of law wrong. And district court judges have an enormous amount of deference on questions of fact. In the meta within decision, the judge sided with the FTC on basically every question of law. And laid out a very clear opinion that said that the way we were interpreting the law was correct. He didn't think that we had the evidence to support a preliminary injunction in that case. So if an appeal would be unlikely to overturn the judge's evidentiary standard, and I don't know that we would want to appeal his findings of law in that case if he said we were right. So I think that's one question. What is the standard on appeal? What are you looking to appeal? And then you also have to weigh, what are the risks of an appeal if you don't prevail at the end of the day? And so I think making sure, I have wanted to appeal cases where I thought the application of the law was really wrong at the lower court level, but where I don't think the application of the law is especially problematic, I think that the appeal is less likely to have, to vindicate the interest that the commission sought to vindicate in the first place.
We move to a series of kind of more specific topics. The first, some in the room who follow the FTC Section 5 authority will know, this set of questions is going to make me sad. But one of the first things that Chair Khan did when she took over as chair was take the 2015 bipartisan lovely statement and vote it down. That statement, if you don't remember, I have it tattooed somewhere. That statement said something like, UMCs will be evaluated on a case-by-case basis under the consumer welfare standard, and if the courts have already addressed the question, we probably shouldn't bring the case administratively. Something like that. It is gone, and one of the reasons for that statement was sort of go back 8 years. At the time, the agency wouldn't litigate Section 5 cases. And when it stand up in court and say an unfair method of competition is X, Your Honor, for fear that, given the case law around UMC, a federal court might say back to us, we'll tell you exactly what it means, and it means something different than you think, Federal Trade Commission. So instead, we piled on all of these. We had, a stack of invitation to collude settlements and no law, right? And so part of it, the impetus for that statement was maybe if we write down a standard, we'll be comfortable litigating some of those cases. So a lot of the idea around the elements of the statement were find some limiting principle. So when the Article 3 judge looks at you and says, tell me what's an unfair method and what is not, I have an answer on both sides of that line. The new standard says, I don't have this one tattooed, so I am going to read it yet. Conduct that is coercive, exploitive, collusive, abusive, deceptive, predatory, or involves the use of economic power or otherwise restrictive or exclusionary can be a UMC. So I have two questions I'll bundle and let you talk about whatever you think about UMC. One is, what sort of conduct do you envision UMC reaching now that it couldn't sort of before under a consumer welfare standard? And then the second is there a limiting principle embodied somewhere in that statement so that, the agency is going to go get a case. It's not, right? It's going to stand up, it's going to go into court, and a judge is going to ask a highly trained FTC, BC lawyer, hey, what's not a UMC under this definition? I wonder what they're going to say. What should they say?
So I'm trying to organize my thoughts in response to that important and lengthy question. The first is I want to point out that the standard is not just the types of conduct that you talked about, but the second prong, which is tending to affect competition. That is unfair method of competition. And that, I think, is really important because I think the meat of the answer that I want to give is that our job is to be faithful to the statutory text that Congress has passed. And if you read the original withdrawal statement in addition to the new Section 5 statement, it really talks about that fidelity to the statute and our job being to interpret the text that Congress has given us, not the text that we think Congress should have given us or that we want to limit in some way or that we want to choose not to apply. And it is very difficult for me to understand how Congress could take existing antitrust law and then pass a different statute using a different and broader set of terms, unfair method of competition, and mean it to be a perfect overlap with the existing law. That seems inconsistent with statutory text, structure, and history. So I think our job is to have fidelity to that. I have heard a lot of criticisms that under the new statement, the Section 5 UMC is too broad. I think if that is your view, your quibble is probably with the statute, not with the commission. And you can have that quibble with the statute. I want to go back to your point about a limiting principle. My dear friend and former colleague, Commissioner Phillips, would always ask this question in every case that came up before the commission. What is the limiting principle here? And I really respect that came from a place of wanting to be small c conservative in the application of government power. However, I don't understand that as a conservative question at all, because to me, there's nothing less conservative than imposing or substituting our judgment for that of Congress. So I would always say to Noah when he would say that, my limiting principle is the law. The law that Congress passed has to be the limit that we use, not some other limit that we invent on our own. And I think that's a really important standard for us to be conscious of in order to faithfully execute our duties. Now, in terms of specifically what counts and what doesn't count, I am confident that we will have the opportunity to litigate these questions and to work through them. And I think I want to be mindful that this is going to be a case-specific question. The first settlements that we put out were the non-compete settlements. Obviously, we have the pending NPRM on non-competes, and this, if it ends up becoming a final rule, I think I would be surprised if we don't find ourselves in litigation over it. And so I'm sure there's plenty of opportunity to have those conversations. But I think that as with everything, we have to look at the law that we actually have. We have to look at the facts in front of us and then apply it as faithfully as we can.
So we had I'm going to bracket our Section 5 debate away from all of these people later. It will involve whiskey. And we'll talk more about it. But in the spirit of getting to everything, let's do the rulemaking. We had a panel that talked about labor and antitrust this morning, and you might imagine the non-compete rule was sort of a big, both from economic and legal perspective, was part of that discussion, from 6G to National Petroleum Refiners, whether or not one finds themselves in the DC Circuit or, I imagine, elsewhere defending the challenge. So let me just sort of go, and I think you've already set up quite nicely. What is your view generally, not tied specifically to the non-compete rule, but your view generally of the FTC's substantive rulemaking authority, whether under 6G or otherwise?
Well, I think we have it. Otherwise, I would not have supported rules or the potential promulgation of either competition rules or the authority that we have to do UDAP rules, which is a different kind of authority and spelled out with more statutory clarity in Section 18. So I think it's important. I do think something that gets lost in this conversation often in DC is there's this sort of, I don't know, ethos that rulemaking somehow necessarily equals heavy-handed regulatory interventional tactics. And I think that those are not the same thing. I think a really important principle under the law is that the FTC can only promulgate rules to address conduct that is already proscribed under the FTC Act. In other words, if it's not illegal, if we couldn't bring an enforcement action against it to begin with, we can't bring a rule. This is not a broader regulatory regime. The reason I like rules is because I think they can provide clarity to the markets ex ante about what kinds of conduct are legal and illegal, and that strikes me as very efficient. More efficient than requiring, for example, a small business to hire an expensive law firm to parse FTC consent decrees to try to figure out what violates or doesn't violate the law. I would rather we say it upfront and more clearly in order to facilitate compliance. So I think that the conversation can get a little bungled around that, and I think that it is actually an expression of clarity, not heavy-handed regulatory intervention that you might think if you only read the Wall Street Journal editorial page.
Fair enough. I read one other thing. All right, let's do mergers. So merger review in particular. So you recently had a statement joined by Chair Khan and Commissioner Bedoya that talked about the HSR process and timing. And it called specifically for extending the 30-day waiting period on a second request and also on a challenge after substantial compliance. So sort of on the front end and on the back end of the HSR process. From reading the statement, I infer that the idea is in part, I think I'll get the quote wrong, but we shouldn't have to have an agreement with parties to do our job under the statute, I think was the spirit of the quote. I got from that maybe what you've observed is parties less frequently entering into timing agreements with the agency sort of over time. So I want to ask sort of a kind of twofold kind of broad question about merger review. The one is talk to me about your views on why the agency needs more time, but I'm especially, because I think it's part of it, interested in the dynamics on timing agreements and if that's changing. If parties are less willing now to do so, why do you think that is, and what does the agency do to deal with that?
Yeah, so the timelines in the HSR Act were developed not recently, and when merger review definitely involved a substantially smaller volume of documents witnesses, technological and economic evaluation of evidence. And it is just not a realistic timeline given the complexity of the mergers with which we deal right now. And so it is, the conventional wisdom has been, and I think I've heard my colleague Commissioner Wilson repeat this, is that if the FTC takes a harder line on merger analysis, then parties are going to be less interested in entering into timing agreements, and that means that we're going to have less time to complete our review. They will certify substantial compliance and put us on a clock, and we'll have to look at like a terabyte of data in 30 days and come up with a complaint. That is a concern. That is a problem with the statute. It is not, the solution, I do not think, can be that we then have to take a less hard look or, as I said in that statement, get permission from the merging parties to do the work that we require. I think it's also reasonable to ask whether too many mergers, too many transactions, maybe not big mergers, but the volume of HSR filings is very high. We look at a lot of filings that we don't end up issuing second requests on. And I think it's reasonable to say, is that appropriate too? So it strikes me that there could be, the argument for the timelines that exist in the Act right now is that if a merger isn't problematic, you don't want to add friction to the transaction. I'm not especially sympathetic to that argument, but I can see where it has a place. What I really care about is if we need to do a more in-depth investigation, that we have the time to do it, and that parties are not able to take advantage of those statutory timelines to prohibit us from doing the job that the law requires.
Daniel has told me I should stop, but I don't want to. So let's do a couple faster, I'll be faster, you do whatever you want, questions. And they're both related. I'll sort of we'll round out on mergers. One is consent, and then we'll talk a little bit about the guidelines. So I think in the latest data that I've seen, there's a sort of a growing FTC DOJ divide on consent decrees. At least it looks that way. In 2022, 40% of, this is from the Deckert database, 40% of all concluded significant investigations ended in consent, and every one of those came out of the FTC. I won't ask you to explain the DOJ. We'll have, maybe I can get Jonathan here next year. But in your perspective, from your perspective, when are consents appropriate? When are they not?
Okay, well, let me start by saying, having been at the FTC since 2018, I can say with 100% confidence that in my tenure, the FTC and the DOJ have never been more closely aligned than they are right now. Oh, you're right. And I think in maybe the history of the two agencies, they were never less aligned than they were in the last administration. So I feel really good about our working relationship with the DOJ right now. And I think that that's a really important and valuable thing, again, for clarity and certainty in markets. In terms of consents, the standard that I use is any remedy that we have on the table going to be administrable? And is it going to actually preserve the competition that was in the market ex ante? And what is the risk of failure? And so I think what we take very seriously, what I know the chair takes very seriously, is making sure that we do not take a remedy that is unlikely to succeed and where the cost of failure is going to be borne by the public, because that doesn't actually do the job that we are supposed to do. Does it mean litigating more sometimes? Yes. Does it mean being more careful in how we address particular remedies? Absolutely. But I think the standard is, how are we going to fully protect competition in the market? And sometimes there isn't a remedy that will do that. Sometimes there is. Again, I think that these are really fact-specific inquiries, and we have to be really careful in generalizing around them.
Let me get one last one in, and we'll do a couple from the audience. So last one, the panel right before the fire drill, that was right before lunch, was on the merger guidelines. And so, the short version of this question is, hey, what's going to be in them? But I'll try to be slightly more tactful. I think, you've got a big evolution in guidelines from 68, 82, 92, 97, 2010. that have been some more incremental, some kind of bigger swings. I think if one reads the RFIs around the merger guidelines, one prepares for a bigger swing than some of the, 92 to 97, let's say, or 97 to 2010. And of course, a key part of the guidelines is, they're not just for the agency, they're so that we can wave them around in court and go win cases in front of Article 3 judges and say, this is how we think about it, this is how you should too. I don't retract the hey, what's in it. So if you want to do that question, please do. But I think the other question is an invitation to talk about what you think would be useful to include in the guidelines. What sort of concepts do you think are hanging around or have been in guidelines that shouldn't be? Or anything you'd like to share around your thinking around the guidelines, their function, and that process at the agency.
Yeah, so let me start with the what's in it question and tell you all the secrets. No, what I am going to tell you, I heard my colleague Commissioner Wilson say at an event a couple weeks ago that she doesn't know what's in them and that she's uniquely been kept from insight into that. I have no idea where the draft is right now, just either. I know that there was a huge round of staff vetting earlier this year, and I think getting staff input is really important, but I don't have any particular insight that I think Commissioner Wilson doesn't have, or access to information that Commissioner Wilson doesn't have. And I think that's fine. I think Chair Khan, AAG Cantor take really seriously the idea of getting them right. And that is an important process because, as you indicate, the guidelines aren't rules with force of law. They are as effective as they are persuasive. And so I think making sure that they are persuasive and reflective of market realities is the goal here. Because if they are, aspirational, then they don't have a lot of effect. And so I think what I have talked to the chair and AAG Cantor about is really making sure that we're accurately reflecting market realities. I am in favor of clarity and simplicity. Sometimes those two concepts are a little bit at odds with each other. Like the more detailed clarity you get, the less simple they are. But I think both of those are, I will say, aspirational goals in having guidelines. And the other thing that I am inclined to think is it never made a lot of sense to me to have separate guidelines for horizontal and non-horizontal or vertical transactions, because many of the transactions, some transactions we see are exclusively horizontal, but increasingly we're seeing transactions that have various algebraic, geometric relationships, horizontal, vertical, adjacent markets. And I don't think it makes a ton of sense to try to think about these as totally separate analytical tools. Instead, we have to look at the whole picture that a particular merger might present and try to understand how to apply the law to that picture.
I think I've surrendered on my questions, and we should invite from the audience. If you've got questions, wave your hand. Someone with a microphone will find you. Cecile is there. Someone should find her. Please identify yourself and ask your question.
Hi, thanks for taking my question. I'm Cecile Lindell with TIG. Just curious, your response to the last question, Commissioner Slaughter, was that you didn't have any access to more information than perhaps Commissioner Wilson might have when it comes to the horizontal merger guidelines. You're talking about the importance of clarity and the importance of these guidelines. Shouldn't all the commissioners have access to what's going on? Shouldn't everybody be contributing? Because it shouldn't, I guess, for better, shouldn't be a team effort?
Oh, yeah, sorry, let me clarify. I didn't mean that I don't expect to have opportunity to consult and weigh in. I absolutely do, and I expect all of my colleagues will too. But, the process that things go through in the commission, as everywhere else, is recommendations get developed. It's really important to include staff input. They have to work through a process, and then we get commissioner input. They get commissioner input at various stages in the process. All I meant is that I think that there isn't, some unequal footing. And what I have said to our staff is, at whatever point you're ready to talk about them with me, I'm ready to talk about them, but I don't need to jumpstart that process if you're not ready to bring something to me.
And yet, as a follow-up, just quickly, you had said earlier that you wish that you were involved sooner in cases. So isn't that sort of a disparate view
So I think,
between cases and the horizontal merger guidelines?
well, not necessarily, because cases usually happen on a specific timetable. And so if we get to the end of a case, let's say it's a merger and we have a timing deadline that we have to, either statutory or by agreement, that we have to follow up on, that's when it's really hard to go back. If it's something like a document like the guidelines where we're not on a clock and we can go back and say, like, hey, let's look at this, then it's different to be able to offer information. I also, we all had opportunity to talk about this early in the process too. My only point is there's not some secret draft to which some commissioners don't have access, and I expect, and I think it's important to get all different commissioners' viewpoints on topics as we go through, because I think that makes our work better. Whether we ultimately have consensus or we don't, I think it's a really valuable part of the process.
We have time for 2, maybe 3 if they're fast. Is it fast? Go ahead.
I think it's pretty fast. David Hatch with The Deal. Commissioner, given Chair Khan's concerns about Amazon's market power, I'm wondering, why didn't the FTC challenge the acquisition of One Medical? And is that a reflection of the limits of antitrust law?
I think I am going to not answer a fact-specific question about a particular matter, because I don't think I could answer it without talking about non-public information.
Could you answer generically in terms of just the obstacles that the FTC faces when you try to challenge technology company acquisitions?
Well, I think that we face obstacles not only in technology company acquisitions, but in all kinds of acquisitions in terms of putting together, doing a thorough evaluation of the facts and thinking about the timeline on which we can evaluate transactions. So I refer to my earlier remarks about the HSR timelines and the amount of information that can come in. But I also think these are very fact-specific questions. I will say that, again, speaking generally, the ability of a company to legally close a deal consistent with the HSR Act is not the same as the ability of a company to close a deal consistent with the Clayton Act. In other words, that the HSR Act would prohibit consummation prior to the required statutory waiting periods, but the Commission will continue, again, speaking only generally, to investigate cases where that timeline isn't always conducive to developing the record that we think we need to make a decision.
Go ahead.
Hey, thanks so much, Joel Richard with Invariant. I think I'd just like to hear your views about the Republican vacancies on the commission. Commissioner Wright mentioned the reputational capital of the commission and potential impacts. I'd like to get your views there. Thanks.
I am shocked that we made it to 3 questions before that came up.
I owe you a beer.
I told him I thought it would be the first question. So look, let me say, I am really sad to see my Republican colleagues depart the commission, and disappointed in it, because I benefit from hearing their views, whether we end up finding consensus or we don't. I like working on a bipartisan commission. I think it has real value for the agency. I've been in the minority. It's frustrating to be in the minority. I totally understand that. But I think it makes the work of the commission stronger to hear and air differing views. And so I'm disappointed that Commissioner Wilson is leaving before there is another Republican nominated and confirmed, and I hope that that will happen because I do think it helps the agency's work. That said, we also hear dissent to actions from the public, from the advocacy community in litigation. So I don't think that we are going to somehow operate in a vacuum. But I do think I'm disappointed that that Commissioner Wilson is going to leave us without that voice right now.
Let's do one more.
Hey, Satya Marar. Hey, so a few weeks ago, we had Diana Moss of the American Antitrust Institute speak here. And one of the criticisms she made of the FTC was that the FTC doesn't litigate enough all the way through. There's too many settlements and consent orders and so on. I was just wondering what your response to that is.
Well, I think I'll just refer back to my earlier comments about where I see value in litigation beyond the remedy that is achieved post-verdict. I think it's true that there can be real value in litigation itself, but that doesn't mean every case needs to be litigated. I feel like I keep saying this, and I sound like a broken record, but these decisions are really fact-specific, case-specific, and reflective of not just the particular case, but the rest of the workload across the agency and the demands on our work. And, they can't, I don't think they could be made, through some sort of rote automatic process. I think we really have to look very carefully at exactly what's in front of us and make an informed, responsible decision at that moment.
We are over time a little bit, but please join me in thanking Commissioner Slaughter for joining us.